Right. Hello, everyone, and welcome. Thank you so much for joining us this afternoon. My name is Emily, and I'm the Marketing Director for Clinkscales Elder Law Practice in our office here in Hayes. We are very excited to bring you the second session of our Spring Lunch with Randy series. Today, Attorney Randy Clinkscales and Care Coordinator Jill Wexler will be speaking to you about essential documents. Please feel free to send any questions that you may have to me in the chat box that's located at the bottom of your screen. And then at the very end of this presentation, we will address any of those questions that you may have. So at this point, without any further ado, I'm going to go ahead and hand it over to Randy to start us off.
Welcome, everyone. Randy Clinkscales. This is, as Emily said, our second Lunch with Randy series for this spring. And as she also said, I'm going to try to leave some time to answer questions between myself and Jill Wexler. Today, I'm going to talk about essential documents and what you and your patients need to know. I'm joined by Jill and Jill Wexler. Jill, hi.
Hi, how are you doing?
I'm good. And Jill is a care coordinator with our office. And Jill, maybe if you can talk a little bit about what you do in your role as a care coordinator in our office.
Sure. I have usually in the main contact person for any clients that we have. They call us for healthcare decisions or healthcare questions and go out and visit them in their homes. Also visit nursing homes and hospitals, wherever I'm needed. I have a social work background, so have navigated long-term care, worked there for about 9 years as the admissions and discharge planner and activities person. So kind of know my way around that setting really well, and just can help families make the best decisions for their loved ones, whether they're at home, getting them hooked up with home health, working with long-term care insurance providers to get through that fiasco and things like that. So that's kind of my role here, is just to pull it all together and get the information out to the attorneys when they need it, and questions about financial situations.
And the reason I asked Jill to be here today is the essential documents that we're going to be talking about. She is really the spearhead in our office with our clients that are under her management on those essential documents. And so, Jill, I know sometimes you go through those documents with them in the office. Is that correct?
Right. We you guys prepare for them, and then we'll go through and kind of either they can take them home and read them, or we can go through them together so that they have questions. Even if I have answered questions, I can go to you if we're in the office and get those questions answered. If I take it to their home, then I'll review them with them there and kind of make sure it's okay for them to sign, or they're able to sign.
And yeah, let's talk about that just a little bit, Jill. And really, it kind of gets into my next slide. But before I do, I just want to emphasize to you, to our participants, this seems like a pretty simple subject, but for me, it is the most important subject in our office, is having these essential documents done. And so a lot of times when we have clients come in, they don't have anything. And Jill, I know sometimes we run into situations where they may have filled out some form they pulled off the internet, or something they picked up at the hospital. Is that right?
Correct. Yeah, real short, quick forms that maybe don't meet all the needs that they need, but that's all they have.
Yeah. And the other thing, well, a couple of things there is that when I'm visiting with the clients, and Jill's visiting with the clients, and let's back up just a little bit, because want everybody to understand in our office what happens is when a family comes in to see us, actually If it's somebody in Jill's territory, Jill actually will take the lead on that file and the lead on that meeting. And so a lot of times, Jill, let's talk about what you do at that first meeting in terms of ascertaining health issues.
Okay. Usually we just kind of get started with just identifying what their current health issues are, if they have any, what medications they're taking, what concerns they and their family may be having regarding where they're staying, whether that is at home or an assisted living, an apartment, or in long-term care. Just try to get a good picture of what's going on in their life, so we know where they're at and we can join them there and help them through the rest of the way. A lot of times I like to get some background history, just regarding where they came from and how they got to where they're at. I think that's very helpful to understand maybe their level of frustration and anxiety over certain things that are going on.
And the other thing that's important, I think that Jill explores pretty thoroughly is, and we call it who cleans off their sidewalk when it snows. But finding out who is it that they're relying on, and who is it that they trust. And all of that helps us determine what needs to go into both the healthcare and financial power of attorney, and what their wishes may be about not only where they reside, but also end of life indications about how they feel about that. And so I know Jill, sometimes in kind of emergency situations, will go ahead and prepare those documents right when they're in the office in that first meeting. Is that correct?
Yes, if there's a surgery coming up or things like that they're not sure of, or a capacity issue where we're having a good day today but we don't know what tomorrow is going to hold, sometimes we will get those prepared pretty quickly and signed.
Yeah, and I want to jump on that last point. If we're concerned about a capacity issue and they're having a good day, we may want to get that done right then. If we feel like they're not having a good day, or if they're not present, I know Jill will actually go out and visit with the client, usually within a week or so. And many times, Jill, is that when you usually take the documents those essential documents to be signed?
Yes, that's the normal time when I do my home visit.
Yeah. And so when I'm talking about essential documents, and I know I'm going to talk a little bit about wills and trusts, but my essential documents are really the healthcare power of attorney, the HIPAA releases, the living will, that sort of stuff, versus the trust and the last will and testament. So again, as I put on this slide, many times we don't see anything in place, so we want to start executing documents. Jill, before we leave that first meeting again, one other thing that you do that's really important at that meeting is talk about the releases that you get.
Okay. I know that we always ask for if there's already power of attorney in place and the power of attorney is there or the client is there, then we will have them sign a HIPAA release, which obviously we ask about their health care and we have a relationship with them and help walk them through changes as they get older. And we want to be able to visit with them about that, whether they're in a facility or not. So we do the HIPAA, the healthcare information privacy release, and make sure that we can send those to the facility or to their doctor. We also do the releases just regarding their finances, so that if we need to have contact with the bank or financial planner, tax attorney, things like that, we have those releases so that we can do that. We also do, like I'm a licensed social worker in Kansas. We have a certified nurse here that works as a care coordinator as well. So we're mandated reporters. So we also identify that the waiver that we have them sign, that there are some people in our office that are mandated reporters if we see abuse or neglect. So I think that's the majority of them.
Yeah, yeah,
now.
and I think the important thing that I wanted to emphasize is that we want to be able to obtain records and so forth so that we can better advise the client, but also get a better picture about what's going on. And obviously, some clients come to us and they're in more critical circumstances. I mean, they may be already on palliative care or hospice care, and so that's going to take us in one direction versus somebody with an early sign of dementia, which may take us in a completely different direction with that client. So again, HIPAA releases are necessary. We'll kind of get into that a little bit more. One of the things that Jill gets asked a lot is that I'm married to my wife, Barbara. Do I need a healthcare power of attorney? Can I just make healthcare decisions for her? And so what would be your response?
Well, I'd probably ask you to make sure, but I'm that Kansas law, you don't have a presumption. Is that correct?
That's correct.
And so, you do need those papers in place because they can't, just because you're the spouse doesn't mean you're the one that they want making decisions for them. And we find that true with lots of clients. Sometimes they want their oldest child, or it's a second marriage, or things like that. And so the actual decision maker is not the spouse in many situations.
And that's really important because again, as Jill pointed out, I don't necessarily have the right to make decisions for my wife regarding healthcare. In fact, Kansas is one of 4 states that you do not have that power. 46 states you do, but Kansas did not adopt that law. And so if you don't have that, and so I will tell you that even before the client comes in, we're asking about powers of attorneys. And because if no one has power of attorney for that person and they don't have capacity, then we've got to do some other things. And so like for healthcare, we may have to get what's called a guardianship, which is creates some of its own issues. If there's no financial power of attorney, we have to get something called a conservatorship, which creates some of its own problems. And specifically, both the conservatorship and the guardianship are more narrow than a regular healthcare or financial power of attorney. Certainly the healthcare one requires a lot of court oversight, and we'll talk about that in a little bit. And the conservatorship just is much more difficult to use in terms of protecting assets and doing those types of things. So Jill, I want to talk a little bit about, and I'll talk a little bit more, and if you've got questions about the financial power of attorney. So one of the documents is the financial power of attorney. And do you have questions about that of me, about what do I want in there or anything like that?
Do I have questions?
Yes, you do.
I guess no. What do you mean?
Yeah, and so just from the standpoint of Jill and I want us to be able to be sure that that we have the ability to get them on any kind of benefits that's appropriate. I know Jill talks to them a little bit about is the power of attorney effective right now, or is it effective in the future? And so if it's effective right now, it's immediate. if it's effective in the future, then it's springing. And so I know that Jill, a lot of her conversations with them is who is it that they want to be that agent. So it's not terribly unusual that we'll draft a power of attorney and Jill will go out and visit with them. And Jill, I think your custom would be to go through who their agents are.
Right. We usually like to just ask them who they trust and who's helping them currently with their finances. Sometimes they have people that are helping them. They are not actually their power of attorney. So that kind of helps guide us as to who do you really need to be that person. And so try to get a backup person as well in case something happens to the one that is helping them. And I think the main question I have from lots of family members are, does it just have to be one person? Can I have multiple people? Does it have to be in a certain order? So those are a lot of questions that I feel like I answer for them a lot. Just trying to say it's really up to you. However you want it to do to be set up is what we're going to do for you. There's really no right or wrong on that.
And I will tell you that right now with our financial powers of attorneys, we like to have our clients redo them every 3 to 5 years. And there's some practical reasons why we do that. But the other thing that from a care coordination standpoint is sometimes, there's a falling out between our client and their agent, or there's a loss of trust. And so we'll need to go in and make those changes. A couple of things I want to point out here on this slide is that, as Jill said, we always want to have a backup. There's about a 10% chance, in my experience, that something's going to happen to their agent. Also important, if I give Jill my power of attorney, and I say I give Jill all the powers in the world, in Kansas, I've left out 15 powers. And that would be like the power to take care of my wife, the power to give money to my grandchildren, to protect assets, to deal with the IRS, to set up beneficiary designations, to open a new account. All of these are things that I know Jill's kind of shaking her head because she knows we do that all the time with clients. And but for a power of attorney, that would not be possible. We can also put in the power of attorney that if a conservator is needed, we can say who that conservator should be. So if I lose capacity and one of my oldest son wants to be appointed conservator, if I put in there that I want my conservator to be my youngest son, then the court has to follow that directive. But those other things that we want our families to understand is that with a couple very small exceptions, a power of attorney is going to be revoked on their death. And so if things are not set up the way that they want them to be set up, there may be a lag or some barriers for their family if things are not set up appropriately, either through a will or through a trust or through a pay on death benefit, pay on death designation, like on an account or a joint tenancy account and the like. You can make the power of attorney set up in such a way that the agent, that's the person that's appointed, has to report to someone. So in my case, my power of attorney says that my agent, other than my wife, has to report to my kids. And so annually, they can demand a report about what's been done with my finances. So let me just tell you one story real quick. A few months ago, we had a lady named Betty to come see us. Her mother had dementia. She had had dementia for quite a while. Betty had visited with a general practitioner. They drew up a rather brief power of attorney. Now Betty's mom is in the hospital. They want to discharge her to a nursing home, and that's when they contacted us. The mother has two children, Betty and a daughter who is disabled on SSDI. Really the only resource that mom has is a home. If I had the right kind of power of attorney, a very strong power of attorney, I could actually deed the home to the disabled daughter and qualify mom for Medicaid without having to sell the home and pay for mom's care until she used up all of her resources. But they had a really crappy power of attorney that we were stuck with. Now, long story, but we were able to get around it to a degree and protect about 60% of the money. But if we'd had a really good power of attorney, we would have been able to protect it all. Jill, let me just talk to the one that's probably most important to you, and that's the healthcare power of attorney. And many times, Jill, I know you're dealing actually with the agent. And that's the person that they've appointed to make healthcare decisions for them. Is that right?
Right.
One of the things that we want the client to understand is that the healthcare power of attorney can be very, very individualized. So as an example, in the power of attorney that I use for myself and consequently we use for our clients, I have a paragraph in there about quality of life and about dementia and about medications if I have dementia. And actually, in my case, and the one that I use for myself, if I have dementia and don't recognize my family, then I actually restrict my agent's powers about what they can do for me. But again, understand that as a general rule, in almost all circumstances, the healthcare power of attorney is going to be revoked on death. And so, Jill, typically, do the clients have a lot of questions about that power of attorney, that healthcare power of attorney?
I don't think as much as the financial one. A lot of times they will venture into, should I have a DNR? Should I have a living will? Which kind of just is a backup regarding their wishes and how they want to be taken care of. The other question that I get a lot is it, do I have to just have the one agent, or can I have all of my children listed on there? That tends to be the biggest concern for them. And one of the things that we like to do when we are having this conversation is just making sure that the client and opening up that conversation about what do you want to happen if the situation comes around. We want your healthcare power of attorney, your agent, the one sitting right here with us, to know what your wishes are, so that when they're making those decisions for you, they're doing what you want. So I think we use this as a tool to open up that conversation. It's kind of a hard one to have sometimes, and I think it helps when we're just making these decisions and just having those topics come up so that they can hear it at least once.
Well, Jill, I think you hit it right exactly on the head. These are great documents, but they're not near as great as that conversation that you have with the agent, so that they're all on the same page. And part of that, there's multiple reasons behind the healthcare power of attorney is actually built around the philosophy that if you don't have permission to render health services to that person, then you're committing a battery. And so the healthcare power of attorney basically gives the healthcare worker the ability to work on that patient, provide services to that patient within the confines of the power of attorney. But more importantly, I think, is to have an agent that's going to follow the rules of that power of attorney and is on the same page with the client. And I often use the example of my oldest son and my middle son. And when I initially prepared my healthcare power of attorney, I named my oldest son until he read it. And then he said, I can't do this. And so I went to my middle son, who is much more comfortable following the wishes that I've expressed in that power of attorney. So if you look at a lot of the really awful cases like Cruzan and so forth, a lot of those really boiled down to the conversations that they had had with their loved ones about what type of care that they wanted. So anyway, it is a really key document. And again, I always recommend my clients sign it right away and then read it. And then if they have questions about it, then we can correct it. But I don't want to get caught without having a healthcare power of attorney and a good agent that's going to follow the dictates. Jill, you've mentioned twice, and I keep forgetting to address it. How many people should be on the healthcare power of attorney? My experience has been that I always recommend just one, but I make it easy for a backup to step in. So in my case, it's my wife. If she cannot be found, it's my middle son. If he cannot be found, then it's my youngest. If he cannot be found, then it's my oldest. And so I don't have to, my issue is that many times healthcare decisions have to be made quickly. And so I don't want to have to gather 5 kids. We actually had one time, Jill, before your time, where we had either 5 or 7 kids. They all had to consent to any kind of procedure. And it took about a month for everybody to figure out that did not work. So again, I try to work with just using one person if I can, or 2 at the most.
And I think we recently had that same situation come up with the financial power of attorney where we had 3 kids, but 2 had to agree and ended up just making things really difficult at the bank, trying to get things set up the way they needed to be set up. So.
Right. Yeah, the only difference between the financial and the healthcare is that with the financial, somebody's not dying.
Correct.
So I have a much more of an urgent need with the healthcare power of attorney to be sure that we can operate that smoothly. Let's talk a little bit about the HIPAA document. And Jill, who do we usually put on there?
Usually the agents that are listed need to be listed on there as well. Sometimes I've had people that are just a neighbor, but they're the ones that they go to, or a friend that they rely on heavily. So anybody that might be calling the medical provider and asking questions about their health. So if they're in the hospital and one of the children are not listed as a POA, power of attorney, then we want them listed on the HIPAA so they can at least, as long as the client wants them on the HIPAA, so that they can at least ask questions and get the information.
Yeah, and again, I know from my standpoint, I like to make them pretty broad, and if they're comfortable with other family members knowing the healthcare information, even though they may not be agents, then I like to do that. I encourage that so that the doctor doesn't have to dismiss somebody from the room if he wants to talk to them about what's going on.
And I think like we have ours that we do here that we can send out to the hospitals. I know when they go to the hospital or doctor's office, you fill them out as well. But sometimes you maybe miss somebody or you're in a hurry at the ER and you don't list everybody that you want. Our clients at least know that we have this on file and we could always send it to the facility or the hospital if they were having trouble getting the information out to their family.
Yeah, and one thing I want to add here, actually a healthcare power of attorney can authorize a HIPAA release. So I think that's important. The next one I want to talk a little bit about, Jill, is the do not resuscitate. And I know this is a kind of a sticky one. We don't actually do these. Is that correct?
They need to be signed with the doctors. To make it an actual order, it has to be signed by the doctor. So we will go over them with them. And actually, I have a copy of one right here that I like the most recent situation I was in. I handed this to the client and I kind of went over what it was saying. I said, but I really want you to talk to your doctor about this. Take this to your next appointment. Well, she left here and went straight there and had it taken care of because she knew she wanted it done. So I definitely explain it to people.
And let me get a little bit technical here for a moment, because there's actually two different types of DNRs. One is an order, as Jill has described, and that can be signed by the patient. It can actually be signed by a power of attorney, but then it has to be signed by a healthcare professional to turn it into an order. The other alternative is that the patient, and as I understand, only the patient can sign a directive. And so the patient can say, I will not consent to a resuscitation. And so, and there's a Kansas case where a prisoner I think in El Dorado, wanted to sign a DNR as a directive, and the prison would not let him, and he appealed it to the Kansas Supreme Court. And the Kansas Supreme Court said that a person has a right to refuse treatment. And so he can sign a directive. Doesn't mean that a doctor agrees with him. Doesn't mean that it's an order. But basically what he has done is he said, you no longer have permission to treat me in terms of a resuscitation. So Jill, let's go on to the living will.
Okay.
What do you understand that this is?
Well, I take this with me when we're going to the home visit a lot of times, and a lot of times people have one and it's very similar to the one that we provide for them. But I just describe it to them that a living will is when you have been determined by two doctors who have physically examined you that you are terminally ill. That is the only time that this would come into play. And then you have the right to make decisions regarding, we have a pretty long list of different procedures that you can say yes to or no to if you are in that situation where you're terminally ill. And so a lot of times I have people who don't want those. They're like, well, I want you to try, those kind of things. So if they're 100% not comfortable or even just have a little bit of hesitation, I will leave it with them and say, go over this with your family, really discuss it. It's definitely not something I ever push on somebody because I think it's an important document. I don't know how often they're actually used, but I think it's a relief for some people to know it's there and that they can turn to it if the situation arises.
And let me address it from the legal standpoint. Jill accurately described what it says. We've actually expanded it to a large degree, but the living will law says that if a doctor relies or a healthcare professional relies on the living will, they are granted immunity from any type of lawsuit. And so you've got to have the magic words in the living will for them to get that immunity. But a couple things that are important. A power of attorney cannot do a living will, nor can the power of attorney revoke a living will. The only person that can make or modify or revoke it is actually the patient or our client. The issue that I've run into with the living will is that, as Jill described, it's only if you're terminally ill. So as an example, is Alzheimer's terminal? Well, I suppose we're all terminal, but no, it's not. And so it leaves some, another good example is Parkinson. I mean, you could go on and on and on, but the living will has some gaps. I'm much more emphatic that the document that you need is the healthcare power of attorney and the financial power of attorney, but particularly the healthcare power of attorney. So, you know, dying in Kansas, as it is in most states, it can get really messy from a legal standpoint. And so we don't have a great process from a legal standpoint just yet. We're still struggling with that. And it sometimes, unfortunately, it gets a little bit political, but we're still not to that point.
But I think too that we encourage people, if they are terminally ill, to look at hospice services. And I feel like that loosens up some of those requirements, especially if somebody's in the facility. So we look at that. There's also some waivers that can be signed, you know, if somebody's supposed to be on thin liquids and they just hate it, you know, that, or thickened liquids, sorry, then they can sign a release to kind of dictate how they want to live in those last days. So I just wanted to get that out there. That it's definitely something that helps kind of loosen up some of those requirements for facilities.
Yeah, and I you know, I don't know, I would strongly recommend anyone read the book Being Mortal by Dr. Gwande. It's an interesting book that he wrote about nursing homes, but it evolved into dying and him helping his father, who was also a surgeon. And one of the things I took away from that book was it's okay to change your mind. The decisions that you make now may be different than the decisions that you make 10 or 20 years from now, or even a year from now, or 6 months from now. And so it's really okay to evolve in your thinking about this. I want to just touch on a couple things here before we get to questions. I generally always encourage people to either have a will, a last will and testament, or a trust. Talk about a will for a moment, and it's a document that says this is what happens when I die in terms of how my property is to be distributed. The issue there is that it's only effective upon two things happening. You have to die, and then somebody has to take it to court and get a court proceeding going. And until those two things happen, that will has no effect. And so the other thing is that sometimes people have stuff in joint tenancy or pay on death or whatever. Those items will not go through the probate process. So if you say, I leave all my property to Jill, but you have it in joint tenancy with your brother, then it's not going to go to Jill. It's going to go to your brother. So that a lot of times with the will, that's what I get afraid of, is that we have a great legal plan, but what the client's doing behind the scenes can really unintentionally frustrate the process. The other one that we talk about with clients is maybe establishing a trust. And a trust is basically an instrument in a process where you put your stuff in it and you're the trustee. But if you lose capacity, you name who's going to control your stuff. Generally, it's going to hold your stuff until your death and then pass it according to your wishes. Sometimes we use trust to protect assets, either for the kids or if sometimes we set up irrevocable trusts that have a purpose behind protecting it from long-term care costs. We have to be very, very careful because of Medicaid rules and VA rules. And so they're great tools, but you just have to know what you're doing and what you're getting into. Let's talk about your role a little bit as a healthcare provider. And boy, I don't want to put you in an awkward position, but just encourage that your patients to be sure they have a healthcare power of attorney and a financial power of attorney. Make sure that they understand that no one has an inherent right to act on their behalf. Be sure that they have an agent that is capable, but also an agent that is willing to act. Again, go back to my son, not willing to act. Many, many more facilities, hospitals, and so forth are trying to make notaries available so that we can get stuff signed there. As some of you know, as part of the COVID rules, there's been a suspension of requiring notaries to be in person, and they can be done through Zoom or FaceTime or other electronic means. There's a bunch of steps you've got to go through, but if you can make those tools available that we could use for executing those documents, and then also kind of know the limits of what the documents are. And then the final thing is keeping them on top of the file. And what I'm talking about there is that particularly like a living will, just to be sure that it doesn't get buried in the process and somebody forgets that there is a living will or a DNR there. I often tell the story that I probably filled out at least a dozen DNRs for my grandmother over time. So I'm going to, Jill, anything you want to add before we open it up for questions?
No, I think we covered everything.
Okay. Well, Jill, I appreciate it. And Emily, are there any questions?
Let me check the chat box here really quickly. Okay. It doesn't look like we have any questions at this point, but I will encourage everyone to please go ahead and type those in the chat box if you do have any, or you can unmute yourself and ask away if that's easier too. So please feel free to do that here in the next few minutes while we close up. I want to thank Randy and Jill for that wonderful information. Thank you for pulling this slide up. I do want to go over just a few of these next things that we have coming up for our upcoming events. We do have one final Lunch with Randy session for this spring series where we will chat about COVID-19 update with our attorney, Jenny Walters, and care coordinator, Amy Kroger. And you can see that that's Wednesday, May 19th at noon again. So you can join us the same time then. We do also have our webinar series coming up that's located on our website, completely free to register. We have two different series and sessions left, 8 things you need to know for the second half of life and how to pay for long-term care on Wednesday the 28th and Thursday the 29th of April. And then lastly, we're very excited to bring back our geriatric symposium in October that we're planning to host here live in Hayes. We are very excited to bring it back to you and hopefully meet everyone in person. So please check out our website at clinkscaleslaw.com/events to register for any of these events, or you can message our office or call us, Facebook message, whatever works for more information. And then lastly, I do just want to mention to everyone that you will be receiving a follow-up email from us here at Clinkscales that will have information regarding that last Lunch with Randy session, as well as a link to this recorded session from today. So you can go back and rewatch it or share with others who might have questions. That email will also include a survey link where you can sign up to receive a variety of different resources from our office, as well as if you want to redeem a free strategy session for yourself, a family member, a friend, or a coworker, you can actually fill that out to request that session with us where we can chat with you about your unique situation. And so we're actually giving this away to you at no cost for attending our session today. And then along with that, we also have the option where you can just call to request a session where you can talk with a member about our office, about any other questions you may have, maybe about the industry, about the healthcare field. Maybe you have a client case that you have a lot of questions about, or you're not sure what to do and you need some advice. We're very happy to offer that option to you as well as to take time to talk with us. We do have one question that just came in, if you two wouldn't mind addressing. It says, when an address for a POA changes, is it necessary to update those documents?
No. No, that kind of stuff happens all the time, and no, it's not necessary.
Okay, perfect. Thank you for addressing that question. I don't see any other questions coming through. So with that, please feel free to message us, email us if you have any questions, visit our website. And other than that, we will look forward to seeing you all again in May for our last Lunch with Randy session. Thank you all.
Thanks, Emily. Thanks, Jill.
Thanks.
Bye-bye.